Okay, let's actually get into this motion now that I've babbled on long enough, I think, with some introductory stuff. So, all right, so these are the basic arguments here. They said, first off, they say that as to these statements that are allegedly defamatory, number one, Ms. Heard has no evidence of direct liability, meaning that there's no evidence that Johnny Depp was directly involved in the statements that were made. Number two, Ms. Heard cannot prove actual malice by Mr. Waldman. So, talking about that actual malice standard, that's a very high burden. Basically saying, even if there was any sort of direct connection between Johnny Depp and Adam Waldman, Johnny can't be liable, because in order for him to be liable vicariously, she would have to first show that Adam Waldman would be liable for defamation, and she can't because of the actual malice standard. Number three, in context, the counterclaim statements are protected opinion. Okay, so we're gonna skip through this. Okay, and we are gonna go through this. It's actually not that long, so I'm gonna read through the whole thing. And hopefully you guys are good with that. All right. Let's see if I can pull this a little bit bigger. Oh, there we go. Very good. Okay. So here we go. Ms. Heard's counterclaim is defective and Mr. Depp is entitled to summary judgment. At issue are three statements, in parentheses, the counterclaim statements, made by non-party Adam Waldman, not by Mr. Depp. Ms. Heard fails to state a valid claim against Mr. Depp for at least three reasons. First, no evidence supports Ms. Heard's allegations that Mr. Depp conspired with or directed Mr. Waldman to make the counterclaim statements. So, Ms. Heard cannot establish that Mr. Depp is directly liable. Second, to the extent Ms. Heard seeks to hold Mr. Depp vicariously liable for Mr. Waldman's conduct, she must establish that Mr. Waldman committed the tort of defamation. But Ms. Heard, a public figure, cannot establish that Mr. Waldman acted with actual malice. Third, in context, the counterclaim statements are non-actionable opinions. Okay. The summary of material facts. Mr. Depp and Ms. Heard had a relationship that ended in a widely publicized divorce amid allegations of domestic abuse, which have been the subject of high-profile, widely publicized litigations in the UK against a tabloid, and in Virginia between Mr. Depp and Ms. Heard. Ms. Heard is a self-described public figure, actress, and activist, and is affiliated with a major film franchise. Ms. Heard seeks to hold Mr. Depp liable for statements that were indisputably made by Mr. Waldman on the theory that Mr. Depp has authorized and conspired with his attorney, Adam Waldman, acting on Depp's behalf, to attempt to destroy and defame Ms. Heard in the press. The counterclaim statements appeared in the UK tabloid The Daily Mail in the lead up to a highly publicized trial in the UK that revolved in part around Ms. Heard's abuse allegations. Statement F is an article with the headline, Amber Heard's sexual violence evidence against Johnny Depp will be kept secret in his libel claim against the Sun, despite him arguing claims should be made public. Good Lord, that is a long title, by the way. I don't understand why that title is so long. Anyhow, that's just my comment. And the article contains discussion of the parties' conflicting contentions. The article describes Ms. Heard's, quote, lurid 300-page filing of her own, cataloging the quote, horrific abuse she claims to have suffered at Mr. Depp's hands, unquote, and sets out a description of Ms. Heard's allegations by a UK barrister adverse to Mr. Depp, who asserts that, quote, Mr. Depp would usually, when under the influence of drugs and alcohol, but not always, flip and suddenly turn into, quote, the monster, and would on those occasions, she says, it was on those occasions, she says, that he lost control and attacked her, unquote. Mr. Waldman's statement appears shortly thereafter, dismissing Ms. Heard's, quote, fake sexual violence allegations, unquote, and predicting that Ms. Heard's hoax would be obliterated at trial. Statement G. So that's the first statement. So note that this one is, it has, so far what we're talking about is a statement made by the lawyer about litigation, right? Because this is in reference to the lawsuit against the Sun in the UK, and the article is about the actual litigation. And it has quotes from the Sun's attorney, and it has quotes from Johnny Depp's attorney. So it's quoting both sides here. And the statements made by Mr. Waldman is it's referring to her domestic violence allegations as fake and a hoax, and saying that they would be obliterated at trial. This to me sounds like just about any kind of statement that a lawyer would make to the press about their high profile case. Every time that an attorney that has filed a case like that is going to um that is going to you know bring a case like this that has both elements in a court of law and the court of public opinion, you're going to have these kinds of statements that are going to be, made, right? And the lawyer is going to, make these statements arguing for his or her client, because you have this is in the UK, so I don't know exactly what the professional responsibility requirements are in the UK, but I would imagine that they're pretty similar to the United States, where, here you have a duty to zealously advocate for your client. And there are certain rules around, statements to the media, but this to me seems pretty normal so far. There's nothing in this that seems to me that is crazy about this statement by Mr. Waldman. Okay, so that's statement F. Statement G. Statement G starts with a headline. Oh wait, you know what? Let me get some super chats here. Tinley, hashtag super chat. Thank you so much. Your bro and Legal Mindset talked about something disease last month. Amber's one. Also, your fave cartoon anime character. Mine's Batman of the animated series. So I don't know exactly which disease you are referring to, but I'm guessing that it's just something that's not the nicest, and that's okay. So my favorite cartoon / anime character, I will say, growing up, one of my favorite cartoons was X-Men, and my favorite character on the show was Rogue. I think for a while it was Storm, but mostly Rogue. So, yeah, she was. Yeah, I think overall for the long haul of my childhood, she was my favorite. Anyway, so thank you for the super chat. In Fantasy I Die said, I believe Amber is guilty. Hashtag believe all women. I'm still not ready to be fully decided just yet, because I haven't gone through everything in detail, but I will say I am kind of leaning that way myself based on what I've seen so far. But I reserve the right to change my opinion because I'm still going through it. So, okay, back to statement G. Statement G starts with a headline, quote, exclusive, I need to report an assault. Listen to the 911 call made the night Johnny Depp and Amber Heard had blowout fight that ended their toxic 18-month marriage, but both claim tape backs up their version of events, unquote. The article describes allegations by Miss Heard and reports that Miss Heard's attorney says that phone records and police department logs vindicate Heard's account of the final shocking episode of domestic violence Miss Heard endured before filing for divorce. The article states, quote, Depp's lawyer, Adam Waldman, said the various discrepancies in Miss Heard's account proved that nothing Heard and her friends said about the events of May 21st, 2016 could be considered credible, unquote. That, quote, this was an ambush, a hoax, unquote, and that, Quote, 2 domestic abuse trained LAPD officers would later provide a pair of sworn depositions saying they saw no evidence of a crime, unquote. The article quotes Miss Heard's then counsel, Roberta Kaplan, calling Mr. Waldman's arguments, quote, fantasies, unquote, asserting that Mr. Depp's representations about the 911 call on the night of May 21st, 2016 are false, and that the evidence, including sworn testimony from multiple witnesses, phone records, and police department logs, supports Miss Heard. So, okay, so the statement in Statement G by Mr. Waldman here is he's saying that the various discrepancies proved that nothing she or her friends said could be considered credible. That doesn't seem like anything crazy to me. And the same thing about, that this is an ambush, a hoax. I mean, it does kind of seem a bit more like opinion. And that 2 domestic abuse trained LAPD officers will. So I think so he's saying that this is what they're going to do. That's not a statement of fact. That is more of a prediction of the future, I guess. Yeah, that's nothing. There's nothing crazy in this statement. I don't see any sort of factual assertion in this one either. Statement H is an article about a friend. And again, by the way, this is also relating directly to litigation that was ongoing at the time. Statement H is an article about a friend of Miss Heard's, Amanda de Cadenet, who withdrew her support for Miss Heard after she listened to audio recordings of Mr. Depp and Miss Heard and concluded that Miss Heard had not been forthcoming with her. The article states Miss de Cadenet feels she was used and misled by Amber and is horrified after listening to Miss Heard be, quote, verbally abusive to Johnny, unquote. The article quotes Miss Heard's former attorney as saying, quote, we believe Amber and we believe in Amber, unquote. And Mr. Waldman as saying, when Amanda de Cadenet recants her support for Miss Heard and testifies against her, we have reached the beginning of the end of Miss Heard's abuse hoax against Johnny Depp, unquote. I mean, so I guess what they're latching on to is his characterization of it as a hoax. Okay, I suppose. Mr. Depp's 5th interrogatories to Miss Heard included the following. Quote, state all facts that support your contention that Mr. Depp is responsible for any damages you contend you have suffered as a result of the counterclaim statements, unquote. To date, Miss Heard's only response is to state that Miss Heard will provide a substantive response. And then it cites to Exhibit 1 at paragraph 3. Now, this obviously cites two exhibits. There aren't any in this version that I have. So I don't know exactly when this interrogatory was sent or when the response was sent, because that is very interesting to me, because another point. So remember how I said that a motion for summary judgment can be filed at any point during discovery, right? So you can get discovery responses and then jump right to filing a motion for summary judgment. If there has been some time in the process of discovery, so let's say this 5th interrogatory, this is 5th interrogatory number 5. That means that if it's the way that I'm used to seeing interrogatories, it means that it's probably in the first set of interrogatories. You only get a certain amount as a default. You can ask for more, usually, but anyhow, so this is probably one of the first bits of discovery that was sent to Amber Heard. And so what happens is, you send a discovery request to the other side, they give a response, and then both of you go on continuing your discovery process. You'll ask for information from one another. You might send subpoenas to other people to get information from them, so that you can maybe depose friends. You can, maybe get different document records from different third parties. Then you can So then, in the process of this whole thing, the response from the other person to this initial interrogatory that was sent at the beginning might then become not exactly accurate because of the fact that there is more information that has not been sent to the person that requested it, right? So basically, there's updated information that should be sent, should be sent to that person. So usually, what happens is when you have a motion for summary judgment in this kind of situation where there has been a lot of discovery that's sort of happened since this particular request, um, where they detail the fifth interrogatory, there could be a situation where Amber Heard gave that response initially saying Miss Heard will provide a substantive response, which basically means nothing, right? That's not like you're asking for specific evidence from them. Like, what is the evidence that you are basing your allegation on? And the response is she'll provide a substantive response. That's like making an announcement that you're going to have an announcement later on. That means nothing. It means literally nothing. So this as a response is infuriating to me as a lawyer who has requested a lot of discovery. Um, getting that kind of a response is annoying to me. But in this particular case, and part of me is like, I always, when I get a response like that, I always want to then send a meet and confer letter to the opposing party to be like, no, this is not a response. I need an actual response. Please send a real response. But in this particular case, the information that they're requesting is information that Amber actually really needs for her case to be able to prove her case. So getting kind of a non-answer basically suggests that she doesn't have any information. So in the process of getting, of the whole discovery, process, there may be a situation where the initial response is, she'll provide a substantive response at some point when, I don't know. So what you do is right before, or at least sometime before filing the motion for summary judgment, you can actually send a supplemental response saying, hey, send us any new information that you have that you didn't send us before when we initially requested this. And then you can basically be sure that they are not going to try to sort of hide the ball from you and surprise you in their response to your motion for summary judgment to say, oh no, we actually do have all of this evidence. And, now you just spent a bunch of time and energy and money because these things take a long time to put together. So now you've spent a bunch of time, money, and expense, whatever, for putting this motion together. And oh, by the way, we have all this evidence. But at the very least, then, this can be successful even if Johnny Depp doesn't win on this motion for summary judgment. It could still be successful in that you get to see the evidence that they do have, because they have to provide it in order to, Amber Heard's team has to provide it in order to survive this motion. Because if they don't provide a response, if they don't provide evidence to back up their side on this, they are the ones with a burden here. So they can get their claims dismissed if they don't properly respond to this motion. So it kind of like, it kind of is a benefit to Johnny in both respects, regardless of whether he actually wins this particular motion. Forever Cuber, thank you so much for your super chat. Substantive response equals question. How do you keep a litigator in suspense? Answer: I'll tell you tomorrow. That's a good one. Okay, so the legal standard for a motion for summary judgment. The court can grant summary judgment as the material facts needed to adjudicate this motion are not subject to dispute. Summary judgment is justified against a party who fails to make showing sufficient to establish the existence of an element essential to that party's case and on which that party will bear the burden of proof at trial. Ugh, that's a lot of like legalese, it sounds like, probably to a lot of people. Basically what this means is so a motion for summary judgment is asking for the court to make a judgment on the other other parties' claims to say no jury should look at this. No jury should take any time to look at these claims because we know at this stage, before we even get to trial, before we even get to picking any kind of a jury, we know that there is not enough evidence for the plaintiff to win no matter what, because they don't have it. There's no evidence for a jury to even weigh. And the evidence that we are talking about has to be evidence relating to a material issue in the case. So what you do is you look at the different elements, in this case, elements of defamation by or alleged by a public figure. And you go through, like I said before, all of those boxes that have to be checked. Each element. Is there evidence that fits in here? Is there evidence that fits in here? Is there evidence that fits in here? And if there's any box that is blank, then that claim has to be dismissed, because you know that there's no evidence that could possibly be placed in there for the jury to be to weigh, for them to decide on. So anyhow, so it's if there is any genuine issue as to a material fact. So, there could be some sort of like light waffling on evidence, but basically, like, if, like I said, in cases where somebody who is making certain claims says or says that they have information, and then push comes to shove, they are requested to give that information, they don't provide it to the other side. This is a really good way to either force that information out, or to show the court they don't have this information, and their claim should be dismissed. Okay. So that's basically what that paragraph means.